that this litigation has not deterred Ms. behavior. It has only taught her to alter her methods.
We're on the record, Jim.
We are on the record in the Nestor case B21. Please confirm your appearances.
Good morning, Your Honor. Shannon Wilson, bar number 9933, on behalf of plaintiff / respondent, who is present with me in court this morning.
Good morning.
Michael Burton, bar number 14351, and I'm here on behalf of who's present with me to my left.
Good morning. This is the time set for evidentiary proceedings on the initiating motion filed by the defendant, as well as the order to show cause issued by the court and related matters. Let me start by asking, are there any stipulations to place on the record, including stipulations regarding exhibits?
Yeah, we have a stipulated exhibit. It actually was prepared as a stipulation in order, and would the court prefer we read these in, or could we just provide them to Madam Clerk and kind of confirm, because we do have this all written down.
For time efficiency, if you would just submit that to the clerk of the court, I appreciate that, rather than reading into the record.
I'm handing a copy of that stipulation that was prepared by Ms. Wilson, provided to me yesterday.
Okay. Any other stipulations?
Mr. Burton and I did also discuss, in addition to what is on the list that was just handed to Madam Clerk, whether or not there was additionally a stipulation to,
I believe you're going to talk about the communications.
the text messages, yes, that new.
So we had stipulated to a bunch of different text messages within what I just handed to the clerk, but then Ms. Wilson wants to provide the court with the entirety of the text messages for about, I think it's about an 18-month period or so.
Correct.
I don't really have an overall objection to that, because I do think that is usually what the court would like to see when it comes to our
The entirety.
The entirety. And so I think her intention, and you can confirm this, Ms. Wilson, that she would just provide them to the court so that if the court wants to further endeavor into the totality of the communications, they can do so, not necessarily to read them into the record or examine the entire communications.
Understood. Is that the intent?
With the, yes, that is the overall intent, and then there may also be specific text communications that we review during the trial.
Sure.
Okay, fair enough.
Yeah.
And that is exhibit, which
It's
exhibit?
that one, did you bring that in a separate binder today?
Yes, that one is exhibit number 80, plaintiff's 80.
80, okay.
And this is
What was the exhibit number again?
80, plaintiff's 80.
80. All right, we are scheduled for the full day. We will break at noon and resume at 1:30 and then conclude at 4:30.
Okay.
Each side is entitled to an equivalent amount of time, and I keep track of time. You periodically may check in to find out how much time you've used, but I'm not here to short circuit the amount of time to present your evidence. If you believe you need an extra day or so, I'm happy to look into that. It may not be immediate that we're able to schedule that, but I'm open to that. But we are scheduled for the full day. You're also each entitled to make an opening statement as part of your allocation of time. I did receive and review updated pretrial memorandums in addition to the prior pretrial memorandums, so I leave it up to you if you desire to use any part of your time to make an opening statement.
Okay, just to be clear, Ms. Wilson and I did discuss the timeframes today and using the day, and both agreed that we would use best efforts, and our intention was to complete it. Yeah.
Okay.
So if we run into an issue where it looks like that may not happen or something unexpected, is it okay we raise that later in the day, or were you looking to have that raised right now?
No, that's fine.
Okay.
That's fine.
Okay.
And one other housekeeping matter, if it pleases the court, it's regarding the court's 3 different orders regarding what testimony would be closed in these proceedings. The court's most recent order on September 2, 2025 said that the child custody evaluation, any mental health records of the parties or the children would be closed and would not be published. Does that mean, is that exclusive to the custody evaluator's testimony, or does that include testimony by the parties as to mental health records and custody evaluation of the parties in charge.
Mr. Burton, what's your position?
Well, I do think, I remember specific discussions about a CPS worker or something like that, and I think we agree that that's not gonna be applicable. We're not gonna have a testimony from a CPS worker. The custody eval and Dr. Bergquist, there probably will be some testimony related to the mental health records and mental health of the parties, but are we gonna exclude her entire testimony from?
Well, I think the question is, so my order is that
Right.
Dr.
Right,
Bergquist's
I
testimony
misused that
would be
word, but.
excluded, but the issue raised by Ms. Wilson is whether or not the party's testimony as to the child custody evaluation should be closed.
I don't think so.
And I would err on the side of openness, so I would be inclined to allow that testimony to be open as it relates to the party's testimony. I'm really more focused, my order was more focused on Dr. Bergquist's
Okay.
testimony.
Okay.
So are we taking the position that when Dr. Bergquist testifies that we were gonna close
Yes.
the title?
That would be
Okay,
my
that's
testimony.
fine.
And that in fact is the court's order from March 11, 2025, that Dr. Bergquist, the entirety of Dr. Bergquist's testimony
Right.
would be closed.
Okay, it's essentially reiterated in the order
Right.
that the court.
So understanding the clarification the court just made, Dr. Bergquist's testimony is closed, custody evaluation will not be published,
Right.
but the parties may testify regarding mental health
Right.
of themselves, the other party,
And that would be
children,
open.
and that will be open.
Yes.
And so I do not want to belabor this point. The court already knows that Ms. objections to that, so I just want to maintain that objection for the record,
Okay, understood.
but we'll proceed.
No, and I appreciate that. I understand that. That would be
Okay.
my direction.
And then, the court's September 2 order also said that information pursuant to SRCR 26 would not be published or broadcast.
Right.
Everybody understands that one pretty well.
And that was also previously ordered.
Correct. And then during the May 27, 2025 hearing on Mr. order to show cause, where the parties were sworn and testified, the court ordered there and noted in its footnote of the June 17, 2025 order that discussions regarding the minor children's medical care and treatment should not be recorded by the media and apart from the court's official record. And those discussions regarding children's medical care and treatment would not be publicly disseminated. That was not, however, part of the court's September 2 order. Is the court adopting that as part of the September 2 order? Or are we going to allow open testimony regarding minor children's medical care and treatment?
I am going to allow that to be.
And so, same objection of Ms.
Understood,
Nestor?
so noted.
Thank you.
Okay, are we ready to proceed?
I probably should be a little, just slightly more specific for the record as to what the nature of that objection is. Ms. objection, of course, is that those things form a compelling interest that outweighs the interest of the public and the press in open court proceedings and records.
Okay, I appreciate that. All right, Mr. Burton, do you desire to make an opening?
I do. I would like to make a brief one. And so just to, we discussed this yesterday, Ms. Wilson and I, so I'm with the defendant here, but we're the moving party, correct? So we're going first, so that's why I guess I'll do this first, and then we're gonna be blending our case in chiefs, Your Honor, a little bit for efficiency reasons, trying to not go back and forth too much. Okay. So, Your Honor, as you're aware, this is a high conflict case, and the central issue here is not whether these parents care for and love these children, but whether one parent, in our position is that Ms. is engaged in behaviors that undermine the children's secure relationship with their father. And I'm gonna explain what we're gonna show and what I mean by that. And so at the end, we're gonna be requesting that Mr. be awarded primary physical custody. He'll explain his work schedule to the court, and and request a 4-2 schedule and kind of talk to the court about what that would look like. Or at the very bare minimum, an acceleration, because there is an accelerated graduated schedule involving the party's youngest child. And that should be, at the very least, eliminated and expedited, but then with protective protocols in place for things like FaceTime access, medical coordination, extracurricular decisions. And we also have, as the court just recently noted, the contempt proceeding related to the August 28th ER visit, where Ms. laterally excluded my client from the appointment and then misused these medical settings to further a narrative that is essentially anti-dad and anti-anything to do with that, including his home, his family, and other, basically just his environment in his house. So the reason that my client filed this motion is making these requests is that this has been just a persistent pattern of interfering behavior from immediately when the parties separated. And this includes recording the children, asking leading and suggestive questioning about whether, quote, something's happened at dad's house, introducing negative messaging that characterizes his home as unsafe, inferior, using medical visits, FaceTime, and even extracurricular activities to fuel this conflict. We're going to present evidence on all this. And regardless of whether she believes in her own mind that she's acting in some sort of protective capacity, the impact on the children is not protective, it's harmful. And we're going to give several examples of why it's harmful during this case. He's going to testify that this litigation has not deterred Ms. behavior. It has only taught her to alter her methods and make things a little bit less obvious. And the same themes, though, are persisting as my client is already seeing the signs that we would expect to see in this situation. Children beginning to resist him, resist his home, resist his family. And this kind of early rejection, it's not spontaneous, Your Honor. I know Your Honor's been hearing family court cases for a long time. This kind of early rejection is not spontaneous. It doesn't just happen. Even if something bad were going on in dad's home, the research shows that that typically doesn't happen. But it is the outcome of what would happen and what you would predict from the undermining conduct that we're going to talk about with mom. You're going to hear from Dr. Bergquist, the custody evaluation. And she's going to testify that these issues with Ms. As far as using probing questions, coercive messaging, that this is harmful to the children, but her recommendations are not in line with what my client's asking, and one of the reasons of that is her report is a little stale. It's been over 2 years. Some of her recommendations I don't think are going to be appropriate at this time, and we're gonna hear testimony on that. And then we're gonna show evidence that Mr. has consistently complied with court orders, followed protocols, and sought to preserve parent-child relationships. You're not going to see anything where he is undermining Ms. role as these children's mother. And we're going to see Ms. herself as a gatekeeper, repeatedly interfering, whether it's withholding recovery days that my client would be entitled to based on his position in the National Guard, orchestrating ER visits timed around custody or vacations, or framing neutral events as abuse. And the result still comes out to be the same, Your Honor. There's these loyalty conflicts that are created with the children and their erosion of their ability to feel safe in both homes, which that's what should be happening here. The children should not have these loyalty bonds, and we're going to show how that's occurring and what mom is doing to cause that. And so the bottom line is we're going to show these children deserve loving spaces in both parents' homes, free from manipulation, fear, and we want a structured custodial plan that has the appropriate safeguards in place to protect these spaces for these parents. And I believe that we're going to show, and experience tells us that the court's intervention, I think, is critical right now before these issues of parental rejection get worse and increase, which we see all the time. That's where this goes. All of a sudden, we're not talking about a 3-year-old and an almost 6-year-old. You're talking about a 10-year-old and a 13-year-old, and then with one parent saying they just don't want to go anymore. And then we go, how did we get here? Your Honor, we're going to show exactly how you get to that situation and how that builds, because that's what we're going to show that mom has been trying to do essentially to dad. And at the close of evidence, we're going to ask that you grant Ms. primary physical custody, or in the alternative, accelerate the current step-up program to some sort of equal time share, eliminate things like right of first refusal, and put in these other protective measures that are in place that would address what is going on with mom and the children, and after all these issues with, like I said, the ER visits, the questioning and the recording, which I do not believe the court will feel is appropriate. Thank you.
I do desire to make an opening statement.
Good morning, Your Honor. This is a case in which an opening argument almost seems superfluous, for your purposes anyway. You have had this case from its very beginning. The motion practice that brings us here today was filed by Mr. in November 2022, just 6 months after the parties' decree of divorce was entered. You have reviewed multiple subsequent motions by Mr. and Ms. oppositions to those, both sides of which have featured voluminous exhibits, which are here in front of you again today. Ergo, a 6-volume set of exhibits. We apologize for the breadth of the record, but that is the record that Ms. wants you to see in an effort to prove that Ms. is engaged in parental alienation. Mr. Burton just admitted that Mr. has been alleging parental alienation against Ms. since before he left the marital residence. This has been a preordained campaign by Mr. against Ms. to drive an ultimate wedge between a parent and a child by asking for primary physical custody, by asking that he have the children on a rolling 4-2-day schedule to coordinate with his schedule as a firefighter. He gets 4 days off, I should have those kids all 4 days, and when I go to work on the 2 days, well then Ms. Never mind the inconvenience of such a schedule to the children or Ms. The asks that Mr. is presenting to you in and of themselves show that he is not supportive of the relationship between and the children. The court is well aware of the dynamics between these parties from the moving papers, from the roughly half-dozen hearings that it's had. And from all of these communications, the thing that is abundantly clear is that these parties have a deep and abiding mistrust of each other, but they have an equally deep and abiding love of their children and a desire to do what is in their best interest. The fundamental problem is that they don't always see eye to eye on what is in their best interest. And when mom does not kowtow to dad's demands, he argues alienation. He argues gatekeeping. Well, the court's going to see in this evidence that there are multiple examples of Mr. gatekeeping too. You can see within his motion for an order to show cause examples of gatekeeping. On that order to show cause, we heard Mr. Burton argue a little bit about that, but this court already had a rather full evidentiary hearing in which it put both parties under oath and questioned them extensively about the multiple subjects that were at issue in Mr. to show cause. And of all of those topics that Mr. presented, the court's ultimate order to show cause focuses on one very narrow, specific part of a medical record to ask whether or not Ms. failed to do as the parties had stipulated in their original decree of divorce in recording or bringing Mr. into a recommendation the doctor was making. And that is all that is before the court on that order to show cause. So I would hope that the court is going to narrowly tailor the evidence on that particular subject, both because of principles of res judicata, but also because time does not permit us to go back through that again. I understand that Mr. Burton wasn't here for that hearing. Mr. presented himself in that capacity, but that does not change the fact that we should not be reviewing those same matters. Mr. Burton's opening argument said that Dr. Bergquist found that mom is engaged in a whole variety of behaviors Ms. is engaged in a variety of behaviors that support Mr. theory of the case. But Mr. reading of Dr. Bergquist's report is out of all proportion and context of the things that Dr. Bergquist actually said. But importantly, Dr. Bergquist said that the parties should continue to maintain joint physical custody. And there were a variety of guardrails, if you will, that she proposed to be put in place for the best interest of the children, not just because of things that what mom was doing or saying, but because of things that were transpiring on dad's side of the equation too. And so the parties then incorporated all of Dr. Bergquist's proposed stipulations into a stipulation in order that was entered in October of 2023. And from that, the parties, or at least Ms. took the parenting classes that she recommended to both parties. And from that time forward, there is a substantial change in the way that the parties communicate with one another. I think the last point that I want to make goes to the argument that Ms. somehow continued a pattern and practice of recording the children and speaking to the children in such a way as to create an atmosphere of alienation of Mr. where, in fact, it was precisely because before he even left the marital residence, Mr. said, "You're engaging in parental alienation. I'm going to show that you're engaged in parental alienation. I'm going to make sure that you don't have these children." It was because of that that she felt compelled to have a recording of certain things to subsequently defend herself, right? One of those features prominently in this order to show cause, the very order to show cause that you asked, "Hey, can you explain this narrow piece to me? I don't quite get what happened here," right? In that particular example, it's a microcosm of this entire case. In that instance, the child makes a comment to mom. Mom immediately says, "I'm going to get in trouble with this. This is going to get me in hot water. I am darned if I do and I'm darned if I don't." So I clicked record. She asks questions in a very monotone, very fact-based, not leading in any sense of the word, and gets information from which she satisfies herself. All right, there's something wrong here, but it's nothing bad happening in dad's house. She notifies dad, "We're going to go to the doctor." She goes to the doctor, and dad then eventually shows up at that appointment, so he's not excluded in any way, shape, or form. And in that appointment, the doctor asks, "Is there any reason we should be concerned about something?" And I forget the precise words, sinister or nefarious, I think were the words the doctor used. And mom said, "No, there's not. I'm not concerned." So this all flies in the face of dad's theory of the case, that mom is somehow trying to alienate him or his other children from their two younger children. And the final point is, these kids, they're doing great. Right? Kids who are alienated from parents don't do as well as these kids are doing. The remarkable thing about this case is these parents, despite the conflict between them, have shielded the kids from it. Thank you.
Or you may call your first witness.
Okay, and just before I do that, Your Honor, I just want to clarify that because Ms. Wilson is correct, I was not at that hearing on the OSC, and And there was a lot of discussion from my understanding. Now, whether something was discussed in the context and even testified to by the parties under oath, whether something would qualify as an order to show cause, I think would be different whether it still could be relevant as proceedings. And I remember one of the examples in reviewing that where my client had made an order to show cause allegation about some scheduling of extracurriculars on his time, and the quote from Your Honor was something like, this doesn't necessarily fall under, I think, the order to show cause, but this could still be problematic in the case, and that's kind of, I guess, what I'm alluding to.
I did note in that order, just so everyone understands the context of that order. The order to show cause was narrowly limited and focused on what I found was the basis for the court to set show cause proceedings. But I did note, and I think this is what you're referring to, Mr. Burton, there were aspects of the evidence that had been presented that were part and parcel, or that I deemed would be relevant as part of the proceedings regarding the evidentiary hearing today. So I'm not excluding that. Just be careful in terms of your use of time.
Okay.
In terms of what is offered and what is presented. Obviously, both parties were sworn at that time. It was somewhat of a mini evidentiary hearing. It wasn't intended as an evidentiary hearing, but it was somewhat turned into that. I certainly would take that into account as I consider the issues before me today.
Okay, sounds good. I'm gonna call Mr.
Okay. Please raise your hand.
You solemnly swear or affirm the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
You may be seated. Counsel, you may proceed.
All right, Mr. Can you go ahead and just state your full name for the record? Okay. And how old are you, Mr.
42,
42. And where do you currently live?
Clark County, Nevada.
Okay, do you own a home?
I do not.
Okay, do you live in a home?
I live in a house with my dad, yes.
Okay, and how big is that, how many bedrooms are in that home?
There are about 4 bedrooms.
Okay. And how are you employed?
I'm a fire engineer with the North Las Vegas Fire Department.
Okay, how long have you worked there?
I've worked there for about 21 years.
Okay, and were you ever a member of the military?
I recently had to resign my commission in May of this year.
And who was that with?
I was with the Nevada Army National Guard as a helicopter pilot.
Okay, and why did you resign that position?
I was given a Hobson's choice. Essentially, it was because I ran out of money and had to self-represent the rigors of having to go through all of that and try to protect the kids. I could not maintain the level of proficiency necessary to safely operate an aircraft and keep the aircrew safe and provide for the protection of my children. So I had to resign.
Okay, I don't want to spend too much time on this, but when you say not being able to maintain, are you referring to meeting credential requirements and things like that?
But they asked me to get back into the aircraft, and due to the self-representation, the continuances, and just the nature of this high conflict matter, I had to resign because I couldn't do everything.
Okay. And how many children do you have, Mr.?
I have 4.
Okay, and so how many are involved in this case?
2.
Okay, and that would be Zeke.
That's yes.
And just to be clear, so right now is going to be turning 6 in November?
Is going to be turning 6 on November 21st.
And is now 3?
Yes.
Okay. And do you have any other children?
Yes.
And those would be with a prior relationship?
Yes. My prior marriage to.
Okay. And how old are you right now?
No, it is about to turn 16 and 14.
Okay. And what type of custody arrangement do you have with?
Joint. It's joint physical custody.
Okay. And what type of timeshare? How does that work?
It's
with your
a
schedule?
3-3 rolling timeshare based off the fire department schedule.
Okay. And so you've been co-parenting, well, strike that. How old were when you divorced from their mother?
How old were they
Yeah.
when I divorced? Whenever we got divorced, they were, well, like, it was in 2015, so would have been like 10 and 12-ish.
Okay. So,
Was 12.
and was 2 years younger than?
Yes.
Okay. And in your co-parenting relationship with their mother since that time, have you ever accused her of alienating you from, or
Absolutely not.
have you ever had other disputes with their mother?
We've had financial and disputes against, or regarding vaccinations.
Okay, but aside from those types of disputes, just to be clear, you've never accused her or, let's say, filed with the court asserting that she was trying to keep the children away from you?
Never.
Okay. So when did you and Miss
September 23rd of 2018, I think it was.
and when did you divorce?
It was late July, I think, July 21st of 2022. Yeah, July
Okay.
21st, 2022.
And did that divorce decree include all your custody and parenting provisions?
Yes, yes.
Okay, was born at the time you divorced?
No, he was born during the divorce proceedings on May 30th of 2022,
Okay,
so 2 months prior.
and so what type of timeshare did you and Miss agree to when it comes to?
It is a phased timeshare that self-advances based on age, and soon when turns 6, they will be on separate timeshares, but it's self-advancing and age-based, working towards an equal timeshare, triggering at age 6.
And how was this arrangement, how did you come up with this arrangement?
Called me, it was right before settlement negotiations had been scheduled, and it seemed to be moving towards trial. She called, and we were able to try to meet in the middle.
Okay, so at that time,
Whenever, this would have been in March of 2022, so no, absolutely not.
okay,
She was pregnant.
and so you're saying this schedule has some graduation periods in it based on the children's ages?
Yes,
And it would have then them on different schedules at different periods based on their respective ages?
yes,
Okay. And at the time you agreed to this, you were okay with this?
yes.
And at this point, did you have the same concerns about to maintain a relationship with, like you do, like we've talked about already in the opening today? Did you have those same concerns at this time?
No, I did not.
Okay. Now, so we talked about, and you mentioned that you informed the court of your custody arrangement. So is that a joint physical custody arrangement with their mother?
With,
Yes.
yes, it's joint physical.
Okay. Has there ever been any abuse allegations against you regarding, or
Never,
not from her mom?
no,
No, not from the school?
never.
Okay. How would you describe your relationship with, from your point of view?
And so, very protective of, they're very close, they love each other, and it's a typical, well, trying to be typical situation where the older children, like, would teach them how to do certain things, like tie their shoes and things of that nature.
Because, okay, so just to kind of reframe this again, so right now, you said was almost 16?
He's 16.
He is 16, okay, and,
He's 14.
okay,
He
and
just
then,
turned 14 2 days ago.
okay, and then you have John, who's almost 6, you said?
Yes,
Okay, and 3, right?
yes.
Okay, so 16, 14, we'll say 6 and 3.
Yes.
Okay, just trying to put the ages of these kids. Okay, so prior to your divorce with Miss, you guys separate households?
Yes, I moved out.
Okay, and at that time, were you seeing, I guess it was only at that time?
Yes.
Okay, how were you seeing after you moved out?
It was very difficult. There were attempts at restricting my ability to see her, and it was just tumultuous. There was withholding and things along those lines.
Okay, and did you, when you say withholding, were there reasons given as to why you wouldn't see?
There were all kinds. It seemed to be a shifting target. There were claims that there were new bruises on them. There was exacerbation of medical conditions. There was all kinds of allegations. It seemed to be a shifting goalpost as a reason for me not being able to see them.
Okay, I wanna jump in. So, so this decree was entered in your divorce decree was July 2022.
Yes.
Okay, and if we could go to, let's see here, one of our stipulated exhibits, which is Exhibit E, which would be these. You're gonna be faster at finding that one than me.
Exhibit E should be 64 on the plaintiff's.
Oh, okay.
Do you want me to go to that?
Yeah, because it's the, oh, yes, I see, now these have the letters on them. Okay. So, was there a time right after the divorce decree, within 10 days, that was taken to the hospital by mom?
Yes, about 9 days after the divorce decree was signed, there were concerning.
I'm gonna ask the question, you're kind of answering, the question first was yes or no, and then we're gonna do the backup. So that's gonna be kind of a theme as we go, so just wait for the second question, okay? Okay, so was there a time within a week or two after the divorce decree that mom took to the hospital?
Yes.
Okay, and do you recall what that was for?
Yes. What was told to me,
By who?
Miss told me that had shot and caused pain, and this needed to be discussed in some way or manner, and it resulted in the ER visit.
Okay, so when you say that she said shot in the, from your knowledge of and the way she speaks, what do you determine it to mean when she says?
It's her, and I'll use the anatomically correct term. She it's her.
Okay, so she refers to her as.
When she's with her mother, that's my understanding.
Okay, so the medical, she had said that, had allegedly said that had shot her in her with a Nerf gun. Was that your testimony?
That's what was told to me.
Okay, and then what, did you go to the doctor's appointment?
No, I was told afterwards. I got a text message that said something to the effect of leaving the ER, and then we need to have a talk after talking about the Nerf gun situation.
Okay, and from your review of the medical records, did they diagnose with anything?
They may have diagnosed her with something, but it was from my understanding, what was represented to the doctor was something different than what was told.
Objection, move to strike non-responsive.
Sustained.
Okay, I will re-ask the question. Okay, so I'm in Exhibit E right now. And I'm going to go to, get past all these custodian of records. Okay, on plaintiff's 4391, we'll go there.
Mr. Burton, can you tell me again which exhibit of,
E, which would be the Summerlin Hospital records.
that's the singular E?
Yeah, and I think that there's multiple records for multiple dates in this record, so that's why I've been moving around a little slowly.
Okay, you'll have to give me a moment, because when I open Mr. binder to E.
Yeah, that's what I was talking about yesterday on the phone. So
Okay.
then he has that other binder that has the stipulated ones in it.
Yeah, it's right
Yeah.
there. No, no,
I'm sorry.
no, you're good.
In the meantime,
Okay.
Mr. Are you on 4391?
I am.
On my way for Ms. Wilson. So.
Go ahead, Mr. Burton.
Okay,
Thank you.
so 4391, I'm looking at this registration form here, and this looks to be dated 12/31/2021. What is this record related to your knowledge?
The 12/31, December 31st, 2021, that was immediately after, are you asking what the medical record is?
Okay, so let me set this up a little better. So this date, the date on this document is December 31st, 2021. Do you see that?
Yes,
Okay. Now, this would have been before your divorce?
yes,
Okay. Was this during a period when you and Ms.
yes.
Okay. And tell me what happened that led to this medical visit referenced in this 4391.
I got COVID. I quarantined with the kids for about 7 days, and immediately after transferring the kids when the quarantine period was over, Miss gets to the ER.
Okay. And what did she complain of?
Bilateral bruising on his arms.
Okay. So this would be, again, before you're even divorced?
Correct.
Okay. And to your knowledge, did the hospital refer this out to anyone like the police or Child Protective Services?
They did not.
Okay. Did Miss ask you about this bruising?
She did.
And was that before or after she took the child to the ER, the children to the ER?
That was, I think that was after.
Okay. Okay, so then. Okay, so go to 4428, please, in the same exhibit.
I'm there.
Okay, do you see the note that says picked up from fathers recently, mother noticed bruises on arms?
I do.
Okay. Do you believe that that information must have come from mom?
Yes, I do.
Now, okay, can we go to date stamp 4441?
I'm there.
Okay, so this is dated 12/11/2021?
Yes.
Okay, so was this the same month, but earlier in the month than the bruise visit?
It was.
Okay, so are you still separated at this time?
Yes.
Okay, and you're seeing, through just an informal agreement with mom at this point?
Yes.
Okay, and is this a emergency room visit record for?
It is.
Okay, and do you know what this emergency visit was for?
I do.
Okay, what was that for?
This was for, so do you want me to read what it says?
No, just tell me from what you recall.
Okay, so this was during the period whenever we were having a lot of I would show up for a transfer and miss be there. And I would get texted later that she had taken her to the hospital, was sick. She had swollen eyes, and that was the reason why I missed was because of the sickness and the eye swelling.
Okay, so if you go to 4444, so all fours,
I'm there.
okay, can you see in the first paragraph on top where it says additional history? It's about 3 or 4 sentences in.
I do.
Okay, can you read that 2 sentences?
2-year-old female, previously healthy, who presented to emergency room for increased fussiness and with noted mild bilateral eye swelling. According to mom, patient was crying all night with his father.
Okay, you can stop. Okay, so we went over records from just two emergency room records from December 2021. And just to confirm, you agreed to the current custody order in around July of 2022?
Yes.
Okay, so you were still giving Miss, for lack of a better word, the benefit of the doubt after these incidents with the hospital?
I was.
Okay. So would it be inaccurate to say that from the very beginning you were accusing Miss alienating the children from you?
That would be an inaccurate statement.
Yeah, okay. Okay, so you mentioned that in July 2022, right after the divorce, there was a medical appointment. Do you recall that?
Yes.
Okay, now what is your recollection as far as what that medical appointment was for?
That one was the Nerf gun, what I call the Nerf gun
Okay.
PP incident.
Okay, so right after the divorce, a medical visit for alleged injury to vagina?
Yes.
Okay, and who did she say caused that?
She said that did.
Okay, how old was the time?
That was July of 2022, so I would have to do like math, 22 minus 2009 when he was born.
Mhm.
So he would have been, what is that? I need a pen and a piece of paper, I'm not good at that. So 13.
Okay, and were regularly left alone with?
Absolutely not.
Okay, and do you recall any incident with the children playing with a Nerf gun during that time period at your house?
Yes, so it was their residential time with me, all the kids were with me, it was during a FaceTime, and I specifically remember looking through the stairs and observing them play with Nerf guns, and there was nothing going on of that manner at all in this FaceTime with, they were just having fun.
Mm-hmm. So Ms. witnessing the Nerf play on FaceTime, you're saying?
Yes, she was.
Okay. So to your knowledge, she was aware there was playing with the Nerf gun even before she went back to her home?
Yes, she was.
Okay. At some point, did you become aware that Ms. was recording?
Yes, I did.
How did you become aware of that for the first time?
It was disclosed to me after I filed the motion to modify.
Okay, and what was disclosed to you?
It was a video in March of 2022 where she was asking suggestive and leading questioning to as suggesting that something happened in my house.
Okay, and so in that video, do you know if Dr. Bergquist reviews that video?
She did.
Okay, and is that the video where Ms. asked, did anyone touch your bottom today?
It is.
Okay, and states,
Yes.
okay, and did you watch this video?
Yes, I did.
Okay, now, and you said you received this, how long after it was recorded?
I don't know. I can't give an accurate answer as to how long it was after, but it was disclosed. I originally thought it was in like their 5th disclosures or something like that, but it may have been in, because I filed my post-judgment motion in November. I think it was disclosed maybe in December, like a month after,
In response to what?
in response to me filing the motion to modify.
What was this video from your opinion, what did it purportedly show that would be in response to what you were filing?
I don't understand the question. Can you rephrase?
You said it was in response to what you had filed, correct?
Yes.
Okay. What is in this video that is responsive to what you filed as far as would refute, for example, anything you filed or clarify?
In my motion to modify, I was alleging harassing claims and things of that nature, and that the kids were safe, and they were otherwise safe in my household, and these seemed to be responsive, that disclosure, that video seemed to be responsive to me filing it.
Okay. So to your knowledge, did mom ever report these statements to CPS that was making on this video?
At that time, no.
Okay. Did she ever make a report to CPS?
She did,
Okay, when did that occur?
during the child custody evaluation.
Okay, tell me about that.
Just that video, well, that video got included in the May 2025 CPS activation. It was included along with a host of other allegations of child sex abuse.
Objection.
Okay, hang on, just-
Hold on, objection, move to strike, lacks foundation, non-responsive.
Okay, so just try to listen to my question and answer the question, and we're gonna move through the parts, okay? So, I asked the question, did she ever, to your knowledge, make a report to CPS? You said yes. So the next question is, to your knowledge, what was the nature of that report? And just limit the answer to that, please.
The nature.
The nature of the report to CPS.
Objection, lacks foundation.
I,
You need to establish the foundation of his knowledge first.
okay, first I established the foundation it occurred. All right, did you ever speak to a CPS worker after that report was made?
Yes.
What is your understanding as to why that report was made or what allegations were made?
Objection, lacks foundation. Still haven't established it.
Sustained.
What further foundation is needed? We have the report made, we have him talking to somebody at CPS, and the next question is generally, what was going on? What more foundation?
It still doesn't establish a sufficient foundation for exactly that particular knowledge of what the witness is about to testify.
Okay, so somebody contacted you sometime, at some point, strike that, at some point did somebody contact you from Child Protective Services?
Yes,
When did that occur?
that occurred on or about June 3rd through 6th
Of what year?
of 2023.
Okay, and you had contact and communication at that time with Child Protective Services?
Yes.
Okay, and after that contact, what was your understanding of what they were investigating?
Objection, same objection, lacks foundation.
Overruled.
What were they investigating?
From after that conversation, what was your understanding as to what Child Protective Services was investigating?
They were investigating claims of child sex abuse occurring in my house.
Okay, and did you have any more specific information as to what specifically they were investigating?
Yes, they were investigating those claims and several videos that had been given to them.
Okay, when you say claims, did you receive any more information as to specifics regarding the claims?
Yes, there was an allegation that had touched or done something to.
Okay, did you learn what specifically he was alleged to have done?
Put hot toothpaste on her.
Okay, and did CPS investigate that to your knowledge?
They did.
Okay, did they interview your children?
They did.
Both? Or,
They did.
did they do any type of interviews with,
They did a forensic interview.
okay, and I'm assuming he was too young to talk to at this time?
That's correct.
Okay, and what was the conclusion of this investigation?
It was unsubstantiated.
Okay, now, was there a time frame given to you as to when this allegedly had occurred?
She said that it was May 12th was when she was told.
When you say she, are you referring to Ms.? Okay. Was there an issue at that time with, strike that, where, you said May 10th?
May 12th.
May 12th, okay. Was he in your home on May 12th that year?
He was there. He was present for that cycle, yes.
Okay, he was, okay. Was he left alone with during that period to your recollection?
For about 20 minutes while I went to go get, due to the timeshare and the transfers and the different kids, the kids being on different schedules.
Okay, because they're on different schedules. There's about 20 minutes, you're saying that was left with.
Yes.
Was there anything else alleged to have occurred during that 20 minutes?
Not to my knowledge.
Okay. So the March 22nd video, or that would be, I'm just trying to, these are stipulated exhibits, so I want to just kind of point the court to the videos that you're referring to here, Mr. So, these videos that you're testifying to now, these videos are contained in your stipulated exhibits?
Yes.
Okay. So we're gonna try to identify those as we go too. What other recordings are you aware of?
There was another recording made on August 28th of 2024.
And what do you know about that recording? Or how did you become aware of that? I'll try to set more foundation. How did you become aware of that recording?
It was disclosed to me after I filed the motion for order for show cause.
Okay, and that recording, that's stipulated exhibit triple J, I believe, is that correct?
Quadruple I.
Quadruple I, okay, quadruple I. And what is on that recording?
It's a recording after custody transfer. Ms. Nestor is asking repetitive and suggestive questions to regarding her.
Okay, so I want two things on this question and on the questions going forward. If you could try to give me the example. So when you say repetitive and what was the word?
Suggestive.
Suggestive questioning, what does that mean? Tell me what you saw on the video that qualifies as that.
She was asking similar questions over and over in a manner that it seemed as if she was not satisfied with what was saying.
What types of questions?
Questions like, where were in the video says her hurts, and then she starts asking where are you and where was who watched you, things of that nature. Did daddy put anything on your and just going down that line. And it's an 11-minute video of this kind of questioning.
Okay, and
That's
this is
what I mean.
quadruple I.
Quadruple I.
Okay, and when did this, to your knowledge, when was this video recorded?
On August 28th of 2024.
Okay, and when was Dr. Bergquist's report submitted to this court? Do you recall?
It was about a year prior.
A year prior. Okay, so this occurred after Dr. Bergquist's report?
It did.
Okay, and so do you recall if there were any other kind of questions on the video to about beyond the ones that you just alluded to of sexual nature?
Yes, there were multiple questions about whether the kids had been bathed because of a rash, whether there were extracurriculars that I took them to. There was made a statement that she was excited about the gift that her mom had waiting for her. And yeah, I think that's about it.
Okay, and then thereafter, that video, are you aware if mom took to any more emergency room appointments?
Yes,
When was the next appointment you became aware of after that video?
it was about an hour or so after that video.
What happened then?
She took to the ER down
Where, what ER?
Sky Canyon ER.
Okay. And first off, did she contact you beforehand and say she was doing that?
She said yes, she did.
Okay, how did that occur?
I was working on my car upstairs taking a shower. I was working on my car and I got the text message and I wasn't initially too concerned about it. And I went upstairs to take a shower and about 30 minutes later, I headed, or 20 to 30 minutes later, I headed en route.
Okay. And what did she tell you at that time why she was taking to the doctor, the emergency room?
She said, says her PP hurts.
Okay. Did she tell you any more than that?
She did not.
Okay. What did you do next?
After taking a shower, I got into the car and I headed directly to the ER.
Okay. When you arrived at the ER, did you talk to any staff members there?
Yes,
What type of staff member, like a doctor or a nurse or?
I was met with a security guard.
Okay, that's the first person you spoke to?
Yes.
Okay. And what was the overall vibe towards you that you sensed when you arrived at the hospital by the staff?
I was being treated like I was an offender.
What do you mean by that?
They were very cautious to let me back and to even let me know I was actually there.
Oh, really? So you? Now, did you eventually get back and were able to see?
Yes, the security guard left and he went in the back and apparently talked to Miss, and I was able to see.
Okay. Now, did you talk to Miss while you were there?
Maybe briefly, I don't recall.
Okay. Now, do you, actually, I'm gonna go to, oh, you make this all harder to find. This is, I wanna go to the Sky Canyon ER records, which are going to be, I have, it's a stipulated exhibit. Do you know, I have some Bates numbers here. 2252. Okay, I think it's gonna be. I wanna go to page 2252, but it's, I believe it's been moved to the stipulated. So this was stipulated as.
Do you need the number? I know it.
Yeah, if you know the number for the Sky Canyon, that would be helpful.
It's either triple A or quadruple G.
Okay.
Light
Is that a stipulated exhibit?
These
It
are,
is.
yes.
It's in here, Mike. It's in the stipulated set that you gave.
Okay.
It's flagged Sky Canyon. I think, like, at least
I
this
see
is
there's
flagged
some-
Sky Canyon. I don't know if it's got that big number.
Okay, I do think. Let's make sure. So make sure I have the updates here. The one I'm seeing is for 11/13 service date though.
It's in the light blue binder. In
In here?
triple N or quadruple G, if you're looking for the August 28th.
Yeah.
The black tabs just indicate the first number because I ran.
You're right.
I ran
That's-
out
that's
of
confusing.
binders.
You said triple N or what?
Triple N or quadruple G. Quadruple G contains multiple records.
All right, I see. Yes.
Sorry.
Do you? Quadruple G.
So that would be these tabs.
Cough.
Okay.
Yeah, that one right there. Okay, so this would be defendant's quadruple G. And it is stipulated too. Okay, so are you there?
I don't have a light blue binder.
Okay. Now, do we have a second copy of this here? If not, I can.
We may have this in.
Yeah, I think, these documents do tend to be in multiple places here, so if we have it labeled as something else, maybe we can do it that way.
Forward. I'm not sure the perception is slide it back if you will.
Be nice if they had put them in order too. They didn't. 8/28/2024. So this is going to be defendants 2248 for the Bates is where I'm at.
Did you find it?
I found it in the one that I have, but what do you,
Okay, which,
we have, you don't have a second binder here, this record in it for you?
I do not.
Now, I do believe these are in Ms. Wilson, so I just try to find it quick. Did you have an idea about where that was? Oh, actually, it should be on the stipulations and give us a, I should point to it, right?
it should,
Yeah. Okay.
Yeah, quadruple G,
That's his.
yeah,
I may just hand him my book in a minute. I don't want to waste too much time on this. I'm looking for him. All right. May I approach Your Honor with, and just hand him the book that I have?
yes, you may.
Okay, thank you. You know where we're at though, right?
are you, is it,
It's that one right there.
it's this, okay.
Yeah. Careful, just opened up. So Mr. handed you an exhibit book that you prepared, and I have it open to quadruple G, and I have it open to, can you read the Bates stamp on the bottom for Ms. Wilson?
DEF 002248.
2248, okay? And that should be medical records for the October 2000, or August 2024 medical visit?
Yes, A2824.
Okay, and that's the medical visit you were just testifying to?
Yes.
Okay, so what, if we go through, can I approach and you can get a little closer to him so I can flip the
Yes, you
pages
may.
with him? Thank you, I appreciate that. Okay, so I'm gonna go through, and on the next page, 2249, what does it say that the purpose of the visit is?
You want me to read the whole thing?
If you can, just read the first couple sentences.
Patient is a 4-year-old female who presents with dysuria. Mom states patient just finished 2.5 days at dad's house and patient complained this discomfort after she picked her up this evening.
Okay, now just to go back to your testimony, because there was a little bit of a break while we looked for this document. You testified that this medical visit was about an hour after the video in quadruple I?
Yes,
Okay. And that was the video you testified that you thought that these questions were suggestive?
yes.
Okay, so now we're at the ER visit, and you just testified what mom brought the child in for. What does the hospital do?
They did a sex abuse assessment.
Objection, move to strike, calls for expert witness testimony, inconsistent, Lux Foundation.
Sustained.
Okay, so did you talk to any medical professional when you were there, a nurse or a doctor?
Yes,
Okay, and did you talk to a nurse or a doctor that was performing medical services for?
yes.
Okay, and after talking to those professionals, what is your understanding of what types of diagnostics or treatment they did for?
Objection, hearsay.
Sustained.
Okay, are you May I approach you?
Yes, you may.
Okay. Okay. On 2252, on the same exhibit, can you read that first paragraph?
Patient is a 4-year-old female, presents with less likely sexual assault, and patient appears appropriate and happy, denies any injury to the region, no fever or vomiting or abdominal pain. I advised UA and good hygiene. If work abnormal, advise close follow-up with primary care.
Okay.
Mom in agreement with plan.
Did anybody explain to you what a wet prep was?
Yes.
Objection, hearsay?
Well, that aspect,
I haven't got there yet.
Overrule.
Yeah.
You just said
I'll
that
rule
anyone
that
explained to you.
And
Right.
do you, what is your oh, I'm sorry. What is your understanding of what prep is?
Hmm.
I'm just asking a question that I'm not asking where you got it from.
You may answer.
Go ahead, you can answer.
Is something that's generally given to, from my understanding, to sexually active adult females to check for any type of infection, including STIs.
Okay. Now, who is Dr. Fung?
She's their pediatrician.
So Dr. Fung is both and pediatrician?
Yes.
Okay. Did you see Dr. Fung for a follow-up after the emergency room visit at Sky Canyon?
Yes.
Okay, how long after the emergency room visit did you see Dr. Fung?
This incident was on August 28th. It was on September 6th.
Okay. Did you ask Dr. Fung about some of these diagnoses specifically?
I did.
Okay. Did you record this conversation?
I did.
Why did you record it?
Because I had ordered the records based on the way that I perceived the interaction at Sky Canyon ER. I went home, I ordered the records, and I read these records right here, and I had concerns
What were your concerns?
that once again, this May 25th, 2023 situation was occurring, where my concern was that there was gonna be another, that essentially putting the kids into the middle of the conflict in this way and searching for evidence of something.
Did you ask Dr. Fung about details of what?
I did.
Okay. And so earlier when you testified as to your understanding, was that understanding based on the information that Dr. Fung gave you?
Yes.
Now, from your understanding, after talking to Dr. Fung, pediatrician, do you feel that was appropriate?
I do not.
Okay. Do you feel that things like and some of the other testing that may have been done were the result of things that Mr. told staff before you got there?
I do.
Have you had problems attending medical appointments for the children that were set by Ms. Pass?
Yes, I have.
What were those problems?
They would be scheduled for when I was at work, or if one of the kids needed a medical procedure, they would be repeatedly canceled in advance.
Okay. Going back to the allegations and the August 2024 appointment, do you have concerns about the types of procedures and testing that has undergone or would undergone based on these types of allegations?
I do,
Why does that concern you?
because medical decision-making should be based on the symptoms that the child has, not statements made in a vacuum.
Do you think that these types of statements have led to having unnecessary procedures done on her?
I do,
Invasive procedures?
I do.
Has there ever been an example where something like a surgery was interfered with for either of the children by mom?
Yes.
What happened there?
Born with, and there were multiple surgeries that were scheduled and canceled, and I found out afterwards about the cancellation.
Why were they canceled?
They were canceled based on her representations to the doctor that was ill.
Okay. Do you believe he was ill at that time?
So, on 2 occasions, I believe he was ill, but on 2, he was not.
Did mom ever give you any reasons why she would be opposed to the surgery?
No,
Did she ever show you opposition to the surgery aside from what you just testified to? Did she ever verbally oppose the surgery to you?
no,
Okay. Have there ever been any issues with vaccines?
yes.
What type of issues?
Miss wants 2 vaccines every 2 months.
What types of vaccines?
Just the standard vaccines.
Okay, so she wants to deviate from the prescribed
It's
schedule?
It's a delayed schedule that she prefers and that I've been unable to keep the kids in alignment with the guidelines. And it led to discharge from their pediatrician.
Okay, so that was my next question I was gonna ask about that. So have you ever had an issue with a doctor or pediatrician over your disagreement on vaccines?
Yes,
Who was the doctor?
that was Dr. David Blank. We got discharged from.
Okay, hang on. One question at a time. So Dr. David Blank, was he the pediatrician at the time?
Yes,
So he was the pediatrician before Dr. Fong?
yes.
Okay. And so when did you guys stop seeing Dr. Blank?
That would have been in March of 2024.
And what was the reason for you guys no longer seeing him?
The delayed vaccine
No.
schedule.
Okay, how did that play into it?
You want me to say what he said? Because I remember what he said.
Objection, hearsay.
No, I don't want you to tell me what he said. I just want you to answer why you no longer see Dr. Blank.
We were discharged for mom's refusals to adhere to the recommended schedule.
Why do you think he discharged you for that?
He repeatedly told us to come back within that 2-month time period, and it wasn't happening.
Okay. So to your understanding, he had criteria for, or let me just clarify what you're saying. Is he talking, he had criteria then for his patients that he wanted them all to be vaccinated at a certain degree? Is that your understanding?
My understanding is that there were cancer patients at the practice, and having an unvaccinated child presented an unnecessary risk.
And did you get a letter from him confirming your discharge?
We did.
Okay, and is that part of your exhibits today?
It is.
Okay, that's not stipulated, right, Jim? That letter?
I don't recall.
Let me double check. I think it's 4 Ws, right?
3 Ws.
3 Ws, is that one in front of you or no?
It's in the light blue. It's in front of me.
Okay. Now, let me check those steps. If not, we're gonna have to move to that one. That's stipulation. This is Okay, so are you open to triple W?
I am,
Okay, do you recognize that document?
I do.
Where do you recognize it from?
Desert Valley Pediatrics.
And did you obtain that document?
I did.
How so?
I sent them an email and asked them for the certified records.
Okay, did you ask for them to prepare a letter specifically, or was that already in the file to your knowledge?
I asked them to just give me everything that they had.
Okay, and that letter was in the file?
Yes.
Okay. What is the date on that letter?
This is the medical records.
Okay,
The date is 3/17/2024.
may I approach, so I just need to review this record quickly.
Yes, you may.
Okay, so this is exhibit triple W, and it has only a few pages? Wait, we're going back. Alright. Did you see, is that stipulated, Shannon?
So you were talking about triple W?
Yeah,
And.
because it's the full, I know that letter, but it is within the records, so that's why I'm questioning it. I handed one of the stips to the clerk, but I brought two. Oh, here it is.
Did you find your copy?
Triple W. Okay, so I don't say it. I got triple L, triple M, R, and I suspect that you wouldn't have stipulated this one because of that. Okay. Yeah. that's stipulated. Okay, and those medical records, you said you testified, you ordered the complete records, everything they had?
Yes.
And that they returned it to you with a custodian of records, is that accurate?
We got that, and we got something in the mail that was this.
Okay. And does that appear to be a true and accurate copy of the document that you obtained and provided to you?
Yes.
Okay. I'd like to move to admit that medical record.
Counsel, your position with respect to the offer of exhibit triple W,
I'm not touching on.
exhibit triple W is admitted?
Thank you. Now, you testified that in that exhibit, there's something from the pediatrician discharging you?
Yes.
Okay, can you go ahead and read that to the court?
What big step are you referring to? Is that exhibit now that it's finished?
Yeah. In fact, I don't want to read the whole thing. This would be on 1854. And if you could just read the first paragraph, it's fine.
Dear parent or guardian of example, the purpose of this letter is informing that you will no longer be we will no longer be responsible for your child's primary care. The doctor-patient relationship we had with has been terminated due to our vaccination policy.
Okay. Now, do you have any information whether mom was contacted prior to this occurring about this issue with vaccines?
How do you mean?
Were you guys given a warning?
We were given multiple warnings.
Okay. So mom knew if she didn't adjust to the doctor's office's vaccine schedule that you would be dropped as patients, your children?
Yes.
Okay. Have you ever had issues with having FaceTime calls with the children while they're with mom?
Yes, I have.
What types of issues?
They don't seem to be, in my opinion, used to support a relationship with the non-custodial parent. They're used for other reasons.
When you say other reasons, and again, I'd like you to, as a rule, kind of fill in these blanks. So what other reasons would you say that they're being used for?
They're used to offer gifts, to plan trips to Disneyland or Disney on Ice, or what the kids can expect when they return to her, to plan play dates, and there's almost always a follow-up question: is there anything else you want to tell me?
Okay, so is that a regular, the behaviors that you just described, is that a regular occurrence on FaceTime calls?
Very regular,
What percentage would you say?
almost all.
Okay. And does she, how do these questions or suggestions affect the children during the calls?
They become dysregulated. They get upset. They ask to return to mom's house. And they say, my house is boring, or things along those lines.
Does she ever talk to the children about how much longer they're going to be at your home, for example?
Yes, she will say things like, I'll see you in 2 sleeps.
And do you think that that undermines your time with your children?
Objection, leading.
Okay. How do you think that affects your children's perception of your home?
It degrades it. They become dysregulated, they cry, they get upset, they ask to return to their mom, but we go back to our normal routine, and they eventually come back down from that dysregulated state, and we go on about our normal situation.
Would you characterize it as disruptive?
I would.
So, have you ever had any conflicts with mom over extracurricular activities for the children?
I have.
Okay, so first, before I ask about the conflicts, tell me what extracurriculars, and I'm really just focusing on because of her age compared to, what activities has she participated in recently?
She's in Brazilian Jiu-Jitsu and learned to skate, and to my knowledge, she's now in hockey.
Okay. And do you support participation in extracurricular activities or sports?
I do.
Okay. But have you had issues with these types of activities being scheduled on your custodial time?
I do. It puts me in a.
Well, hang on, just over, so have you had issues with that happening?
Yes.
Okay. And tell me about, first, how that would occur. How would things get scheduled for on your time?
How would they get scheduled?
Yeah, just tell me the process. How does this happen?
So initially, we do share communications about their extracurriculars. From the initial notice, I have supported in the history of the last couple of years. I've taken to multiple extracurriculars that were occurring, that scheduled, that were occurring during her residential time with me, if that answers your question.
Okay, and so has the scheduling on your time presented any sort of conflict between you and, strike that, has that ever disrupted activities that maybe you already had planned?
Yes, I've had to reorder and reschedule our day based on the way that usually it comes through on a text message, and I'll have to either, I'm put in a no-win situation. I either have to reorder the rest of the 3 kids' day, or I have to disappoint and not take her to that. And there's been times whenever I've done both. I've either disappointed her, it's just a no-win situation, or reordered the entire day for everyone else.
How would you prefer to co-parent regarding extracurriculars to avoid issues like this?
In this situation, I think flexible drop-in style sports are gonna be the best way forward. There, unless we mutually agree on a very involved team sport.
Do you see something like that possibly being more likely when it's older?
Yes, I do, especially with when I learning to drive, and they can do their own, and take themselves to their own sports and all of that. So I do see an increased ability as the kids get older to do that.
Do you agree that as children get older, they often start selecting their own extracurriculars?
Absolutely.
Have you ever had any issues with mom monitoring you outside of like co-parenting issues, that basically just where I'll use the term monitoring you or keeping tabs on you?
Yes, she followed me to my Army base and was photographed my vehicle in the parking lot and made some references.
Okay, when did this occur?
That was, I don't remember the exact date.
After the decree?
Yes.
Okay. Did she tell you why she was following you?
She was clocking my van and gathering intel.
And how did you receive that information?
She disclosed it during discovery.
Okay, so just maybe a little less formal. How did you, not in discovery, but at the time when she says, I'm gathering intel or clocking my van, did she tell you that at the time, or you only learned that through like a discovery response, just to clarify?
I learned it through discovery.
Oh, okay. How so?
In an interrogatory.
Okay. Okay, has mom ever provided with a smartwatch?
Yes.
When did that occur?
Objection, foundation.
Sustained.
Okay. So we're talking about mom, you said she was following you and clocking your van and gathering intel. Have you ever had any issues with mom using to gather information?
Yes.
When did that occur?
It's occurred multiple times, but there was one particular incident involving a smartwatch.
What was that incident about?
She sent to my house with a smartwatch with multiple recording devices.
Okay, objection, foundation, assumes facts.
Sustained.
Was there,
Sorry, and move to strike the testimony.
Sustained.
Thank you.
have you had concerns in the past that mom might be spying on you, let's say, or collecting information?
Yes.
Have you ever had concerns that she was using children to do the same?
Yes.
Was there ever a time where something occurred that made you think mom was actually doing that?
Yes.
When was that?
A smartwatch was sent to my house.
Okay, how was that sent to your house? Please elaborate on that.
The smartwatch was given to my daughter, and at transfer, she had it. She was wearing it.
Okay, and who gave her the smartwatch?
From my understanding, it was
Objection, foundation.
I think I've walked us all the way through.
Right, but as to his knowledge regarding.
Okay, well, where it came from?
Correct, so
Okay.
it is sustained.
Okay,
Sustained.
so did you observe this watch on?
yes.
Okay. Did you ever ask mom where the watch came from?
I sent her an email.
Objection, move to strike, non-responsive.
I thought did you ask her? I sent her an email.
And I'll accept that, so the
Okay.
objection's overruled.
Okay. And did she respond to the email?
Yes.
And how did she respond?
She said that her mother had given it to as a birthday gift.
Okay.